Okay, so this is Erin Somerville picking up on the second part of incorporation. So, like I said, it's case by case and it's done slowly. The First Amendment has a number of components. You have religious freedom, which you could break up itself into two parts, your freedom of religion and your freedom from religion. And then you have freedom of speech, freedom of the press, freedom to assemble, freedom to petition the government. So, when we say that the First Amendment has been incorporated, it was not one case that says, hey, states, you have to respect all parts of the First Amendment, but rather it was a few cases specifying that no state shall deny you of this privilege. So, many components to the First Amendment. We could say it has these 5 parts: religion, speech, press, assembly, petition. And a number of cases were needed in order to incorporate the First Amendment. So I'm going to go through 4 cases that worked to incorporate the First Amendment. Gitlow v. New York, 1925. This is the first incorporation case on our list. So the process starts in 1925 when freedom of speech, your freedom to speak your mind, cannot be abridged by your state. A few years later, another First Amendment right, freedom of the press, is incorporated in Muir v. Minnesota. Almost a decade after that, in Cantwell v. Connecticut, the Establishment Clause, which is the half of religious freedom that separates church and state, that is incorporated. Your state cannot impose a religion on you. And then Everson v. Board of Education, 1947, incorporates the Free Exercise Clause, the other half of religious freedom that makes sure you can freely exercise your religious beliefs. So every time the Supreme Court ruled on one of these cases, they connected a right in the Bill of Rights, so like freedom of speech. They identified that that is your fundamental freedom, and they added in the Due Process Clause of the 14th Amendment, that you shouldn't be denied due process, that you have no state should abridge your privileges and immunities. So when it marries those two, the 14th Amendment, Section 1, with some liberty guaranteed in the Bill of Rights, then you have incorporated some right. And what that tells every state is you may not abridge that right. In a sense, it nationalizes that right. What it means is that is not something you're guaranteed because the federal government's going to follow these rules. That is something you're guaranteed because your state is supposed to follow those rules too. So you got a right from the Bill of Rights, you add in the 14th Amendment, and now you have an incorporated right, a nationalized right, meaning no matter where you are in the country, you're supposed to have this right. So whether you're in Florida, Texas, California, this is a right that you are supposed to be guaranteed because your state is not supposed to abridge that right. So how we view the Bill of Rights, it's been kind of an evolution of our perception of the Bill of Rights. If you look at the Bill of Rights, it's actually about civil liberties, meaning that these are your freedoms from government. But the way we tend to view it now is like, these are rights that the government's supposed to protect, and that's just not exactly the case. But to give you an idea of how we frame the Bill of Rights now, for example, you have free speech. You can speak your mind. It's a free country. You can't be imprisoned for your opinion. But you can be silenced, essentially, by your employer, or your employer might have grounds for firing you based on what you say. You can't walk around and say whatever you want free of any consequences. You should be able to walk around and say mostly what you want free of governmental prosecution. But no, of course, if you say something that your employer doesn't like you saying about their company, they could have grounds for firing you. And you can't say, hey, freedom of speech. But yes, in the 18th century, 19th century, the Bill of Rights was viewed as a list of things that would ensure the government stays out of your way so you can be more free. And we tend to now think about the responsibility of the government to somehow protect our rights. So let's go through civil liberties versus civil rights. Civil liberties, which is what the Bill of Rights is about, these are supposed to protect you from the government. So it's a guarantee of your safety, whether it be your physical body, your opinion, or your property, your safety from arbitrary acts of government, meaning that the government cannot take your property, take your liberty, without following procedure, due process. So when we think civil liberties, government stay out. Civil rights, this term refers to when the government steps in with the goal of preventing discrimination and promoting equality. These are the positive acts of government that are supposed to make whatever the Constitution says a reality for all people. So pretty much all civil rights in the modern era come out of the 14th Amendment. And that you should have equality, at least equal protection under the law. So we, earlier in the semester, looked at two dilemmas, the original dilemma and the modern dilemma. We're bringing it back in here because it's relevant to this topic. The original dilemma refers to how can you balance freedom and order. We want both. All governments should provide order, and we value freedom. But they come at the cost of the other. They're mutually exclusive. And the modern dilemma presents this other balancing act that we try to do between values that most of us agree are good, but once again, you can't have both 100%, and that's freedom and equality. So how this matters to what we're talking about, civil rights and civil liberties. Essentially, I'm going to place civil liberties on one side and civil rights on the other side. See if you can pause it and take a guess. Okay. So civil liberties is going to fall on the original dilemma side. Now, to remind you, the original dilemma is a post-American Revolution question. We've won the war for independence. We're going to set up a new government. How to make that government orderly without infringing upon liberty. And so most civil liberties issues, whatever the topic is in whatever the time period, if we call it a civil liberties issue, you can probably boil it down to this question about freedom and order. So we know that today we compromise some liberty for the sake of security. When you go to the airport and you have to go through TSA, they can look into your bags and they can do a body scan. And that might feel like they're infringing upon your privacy, upon one of your basic civil liberties. But we willingly give it up for security. But how to balance that? Where is that line? Whenever the Supreme Court takes a case about civil liberties, you're going to notice they go to the Due Process Clause. The states need to guarantee your freedom and balance that with order. Okay, the modern dilemma is a post-Civil War question, and again, trying to create a more egalitarian society. Let's do an example for this one. Well, currently, let's see, we could look at gay rights. That's a big topic these days. Let's look at pay. Pay for let's look at pay. Pay for whether you're thinking minimum wage or equal pay for equal work. We want to live in a place where people are not discriminated against, that you're not paid an unfairly low wage or salary because of the color of your skin or your sex. But by imposing that, by requiring that, it would require a lot of governmental action. And that action could range. Our government actually doesn't provide a whole lot of safety net to guarantee that equality, but you can file a complaint with the EEOC. You can sue in a court if you believe you've been discriminated against with regards to your pay, as we saw with the Lilly Ledbetter Fair Pay Act. But if we think about governmental involvement in this arena, the government is now getting itself involved in employers' freedom to hire and negotiate a salary or a wage, and we're infringing upon a potential employee's ability to negotiate. So if we can imagine minimum wage is raised to $15 an hour, which would be great for a lot of people. But it's still not going to, doesn't mean everyone's employed. There's still going to be unemployment. But what about your freedom as a potential employee, your freedom to agree to being paid $14 an hour? Sit and think on that. You know, if you're sitting here going, I'd like a job and I'm willing to work for $14 an hour, what about your freedom to accept that job without the government stepping in? So these are complex issues, but whatever topic we're looking at, if you can boil it down to this freedom versus equality, freedom versus order, that'll tell you if you're dealing with a civil liberty or a civil right. At the end of the day, for the Supreme Court, when trying to interpret civil rights and civil liberties, they're always going to the 14th Amendment, the Citizenship Amendment, that looks at due process for civil liberties and equal protections for the 14th Amendment. So in class we watched a video about Gideon v. Wainwright. This is the case that incorporates the 6th Amendment. So what you should do is read the link, the oye.org link I have below, about Clarence Gideon's story. You should have a few notes on his story. You should have a few notes on the constitutional question and answer. And then take some notes on the effect that this decision has had on our criminal justice system.